Welcome everyone. My name is Claire Harrison and I head up the Business Awareness Unit in the Export Control Joint Unit of the Department for International Trade. I've been in this post for 10 years and have previously worked in other government departments, including a long stint in overseas trade promotion. I'm delighted to be joined today by Adrian Bond, our esteemed trainer for business. Adrian has been the ECJU training manager for over 5 years, and with his engineering background and experience as a technical officer, you'll benefit greatly from what he has to say. The Export Control Joint Unit was established in 2016 following the MOD Strategic Defence Review. It's one of 3 joint units across government. ECJU brings together staff who administer strategic export control functions, including from the Department for International Trade, the Foreign and Commonwealth Office, and the Ministry of Defence. Other departments in the decision-making process include GCHQ, the National Cybersecurity Centre, and Department for International Development. I'd just like to say many thanks to FIA Connect for enabling us to join this event and to talk about UK export controls. We are in unprecedented times, and this year the Export Control Joint Unit had booked a dedicated stand at the Farnborough exhibition. It would have been good to meet all of you who are listening to this webinar recording, but I think this is a great idea to be able to talk about such an important subject and to hopefully signpost you to where you can find out more information on the processes that will enable you to export controlled items responsibly. The presentation will provide you with information to find out more, and we will answer a few questions. But as it says here, the webinar content has no force in law. Responsibility for export control compliance sits with the individual or the organisation who has right of disposal of the controlled goods, software or technology. We will be covering various aspects of the current laws as they are in July 2020, but they are subject to change. Your businesses and the items you work with are all unique, which is great. So as we cover the general aspects of export controls, you'll need to look further into them to see how they affect your business. And if your activities appear difficult to fit into these controls, then please get the extra advice you need to ensure you comply with the laws. Nothing we say today will absolve you of that responsibility. This is what we'll be covering today. Talking to the FIA organisers beforehand to be able to appeal to a wide range of delegates, we thought it would be good, as well as giving an overview of the controls, to look at some of the recent announcements made by the Export Control Joint Unit that could impact on your trading plans. I've also got a few hints and tips about compliance and pointers to how you can keep informed. The Export Control Joint Unit is the strategic administrative authority promoting global security and facilitating responsible exports through a system of licensing in which risk is assessed. The government recognises every country has the right to defend itself. The defence industry in the UK is worth around £15 billion annually. Export controls works to ensure non-proliferation of the build-up of weapons of mass destruction or use of military equipment for non-defence purposes. So that means, for instance, using equipment against the country's own people or against a neighbouring country to claim sovereignty, but more of that later. ECJU administers the licensing of trade-controlled and export-controlled items and activities. This slide outlines in brief what this covers. There are a number of strategic export control lists, which we'll be looking at later. As you'll see, it's not just the finished goods which are controlled, also controlled of the software and technology or know-how to design, develop or modify the controlled goods. more later. Let's look at the times when you will need to use a strategic export license. Firstly, the obvious one is if you export this type of controlled item to an overseas customer. Some of you, however, may be mainly supplying military and dual-use controlled items to UK prime defence contractors, so that's a UK transaction. However, if you're subsequently required to export the items to an overseas end user, say as a replacement spare parts, or you've repaired some components which had previously been supplied directly to the UK prime, and you are sending them to an overseas party, you will then require an export license before shipping. Other incidents when you will need an export license include if you're exhibiting controlled items at an overseas trade fair, or are responsible for returning exhibits to an overseas partner after they have exhibited at a UK trade fair. Sanctions restrict trade with particular countries. Again, we'll go into that in a bit more detail later, but I will flag at this point the need to know about technical assistance and financial assistance controls which apply to sanctioned destinations. Looking at the third bullet there on trade controls or trafficking and brokering. Global supply chains control where items are made, stored and sold from. If you have a sister, a subsidiary or a parent company in another country who are supplying to the end user in a third country, trade controls will apply to you and you will need a relevant license for the activity. So, for instance, if you've received an order for military items from the third country, but you instruct your subsidiary overseas to supply them directly, you'll need a trade license, a trade control license from the ECJU. You may also need a trade control license if you're involved in the supply of finance or freight services for specified items if they're moving between two third countries outside the UK. And then there are controls on items that may not be on any list anywhere, but because of their intended end use, that could be for military end use or even weapons of mass destruction purposes, they also require a license from us. Again, note the technical and financial assistance license requirement. It's fair to say at this point, if any license application is not approved, the goods, the software or the technology cannot be exported legitimately. As it says here, the MOD Form 680 is MOD's, on behalf of Her Majesty's Government, their process for protecting UK's security and foreign policy interests, and which contributes towards the overall HMG export licensing procedure. The MOD Form 680 assesses the release of equipment or information which is classified as official sensitive or above. MOD's primary concern is ensuring equipment or information is safely released without compromising the UK's national security interests and that of its armed forces. The categories of MOD Form 680 approval are market survey, initial discussions, promotion, demonstration in the UK, demonstration overseas, training and through life support, so that includes maintenance and repair. And don't forget, this is all concerned with the release of equipment or information classified at official sensitive or above. I promised earlier to come back to sanctions. So let's look at this map. It shows where all of the sanctions are in existence through the various international sanctions regimes. If a country is in sanction, or there's an arms embargo, or other types of trading restriction, you can't just export the effective items without a license. Sanctions are imposed from several sources. Could be the EU, It could be United Nations. There are sanctions that cover the economic states of West Africa and several more. Sanctions are imposed for a number of reasons. For instance, a hostile takeover of another country, international concerns about a non-civil nuclear program, actions, policies, activities repressing the population, concerns about peace stability, or development of WMD programs. And as you listen back on this, it would be a good idea to think about some of the countries that maybe some of those things actually relate to. But if you need to know more, there's some great information on gov.uk about exactly where the sanctions apply. The sanctions can take several forms. Arms embargoes prohibit the export of anything on the UK military list without a licence. Trade sanctions are restrictions on non-controlled items, so they're not in any list, but they're controlled as a means of hitting the economy of the country for which the sanction has been imposed. So, for instance, there are sanctions on luxury goods going to North Korea. Some countries have oil and gas sanctions imposed on them, particularly if they're in the an oil producer. Financial sanctions affect your trade with named individuals. So if the named individual is on a financial sanctions list, you won't get paid. Best thing to do here is to check the Office of Financial Sanctions, or OFSI, website, and they are part of HM Treasury. In all cases where sanctions are concerned, you will require an export licence, and in the event of financial sanctions, a licence from OFSI. If your items are not controlled, but you are concerned about the end user, if you are sending them to a sanctioned or embargoed destination, you can apply for the end user advice service, which is available on Spire. I'm now going to pass you over to Adrian, who's going to be covering things in terms of the controlled items in much more detail. Adrian.
Thank you, Claire. I'm returning to the control list that Claire spoke about before. Most of the lists of controlled items are developed in negotiation with various international regimes. The UK is represented on all of these. The two main lists are the UK military list and the EU dual use list, which derives from EU regulation 428/2009. Other lists come from other legislation, such as radioactive sources controls, human rights, torture lists, etc. There are also a list of firearms from the EU Arms Firearms Directive and a UK dual use list. The military list is made up of 22 entries, including weapons, aircraft, highlighted here in bold, unfinished goods, specialist production equipment, software and technology. These items are found at the beginning of the consolidated control list, about the first 40 pages, and the term often used is, has the item been specially designed or modified for military use, or variations thereof. The upshot is, if your customer or potential customer is a military and you design something for them, then it is likely to be in this list. And once it is in the list, it stays in the list, as the original design intent can't change. Even though these items previously used by the military are often used by non-military entities. Similarly, just because the military is using an item doesn't typically change its original design intent. For example, a waste paper bin from a high street shop being used by the military doesn't make that bin specially designed for military use, so not likely to be listed here. The military list additionally describes certain equipment not designed for military use, such as hunting rifles, and in addition there are certain paramilitary goods, such as riot shields. If your item listed is in this list, then you may wish to record it for future use, as you'll need a license to export it outside of the UK. Next slide, please. So in deciding whether an item is on the military list, we have to ask the question, has the item been designed for military use? As an example here, there are two very similar looking aircraft. They are both made by Lockheed, and share common features and components. Although the C-130 Hercules on the right was designed for military use and therefore ML10A, the L-100 on the left was not designed or modified for military use and therefore isn't military listed under ML10A. However, there are many components in both aircraft that are specially designed or modified for military use. So when a UK exporter wishes to export these components by themselves, they need to carefully consider each of the goods against the UK controls. Next slide, please. Conversely, here we have a commercial Boeing 767. That's the aircraft on the left. And it isn't likely to be in the military list, although we'd have to consider any modifications. Although on the right, there's a 767 which has been heavily modified to become an airborne warning and control aircraft, an AWACS. This is therefore described by ML10A of the controls. And although this AWACS version will have many bespoke parts that are specially designed and modified for military use to carry out the AWACS functionality, and therefore be on the military list, many parts are standard commercial 767 parts, and therefore not described by the military list. However, those parts may still be described by the dual use list, which Claire will cover later. Next slide, please. Looks can be very deceiving. So although colour and user can provide clues as to whether or not an item may be in the military list, more research should be carried out to do a full control list classification under UK law. For example, the RAF's Airbus Voyager in-flight refuelling aircraft is described by ML10A of the military list. This is regardless who is using the aircraft between refuelling missions or what colour schemes they spray it. And conversely, you'll be amazed at what non-military items we come across, which people want to look military, like this Citroen C3 Camouflage Edition. So when you apply to the Export Control Joint Unit, please provide document evidence to support your application, as one of our engineers and scientists will need to be able to carry out the assessment again based on the information provided. If there isn't enough information, or if it isn't clear, we may have to temporarily stop your case while we request for further information. Key point, all items, software and technology on the military list require a strategic export license regardless of destination. I'll hand you back to Claire to talk about dual use items.
Thanks, Adrian, and apologies for moving the slide over. So, dual use. It's a little less obvious than the military list. To explain it, there are items which have not been designed to a military specification, which Adrian's just been talking about, but they're items that can be utilised as a component in a military item. And this is because they've got a very high technical capability in the characteristics of the control description. So unlike Adrian, I'm not a technical person. So think about something like a helicopter or another aircraft, and then look at those headings again on the left-hand side from category 0 to 9. An aircraft or helicopter uses electronics, it uses computers, telecommunications equipment, sensors, imaging equipment, cameras, guidance equipment, and all of these could be used in a military end use. And that's before even looking at category 9, aerospace and propulsion. Key point in all of this is that all the items on the dual use list require a license for export outside the EU. There is free movement across the EU, except for items on an annex to the EU Dual Use Regulation 428 of 2009. If you know the items are controlled and you're exporting to the EU, you must state that on the shipping documentation, as they may be re-exported outside the EU at a future date. We publish all of the lists in one document, very helpfully, It's called the Consolidated List of Strategic Military and Dual Use Items that require export authorization. It's updated at least twice a year, so make sure you're always referring to the latest correct version. It's available as a download on gov.uk, and we're going to give you further details about gov.uk later, so no excuse for not looking at it. So we're looking now at the dual use goods categories again that we were just talking about. What I'm going to do now is just give you some pictures of dual use controlled items so that you can see the types of things that are controlled in these lists. I like that one. Okay. Those are all pieces of kit that are controlled under these dual use goods areas. So we have, for instance, radar, cryptography, we have control instrumentation, cameras, sensors, machine tools, etc. Now what I'm going to do is I'm going to show where all of these fit in the categories. So nuclear materials, that's a piece of carbon fibre, and that's controlled under special materials. Computer chip, electronics, cyber, camera there, sensors and lasers, helicopter, marine, all types of marine equipment in there. And then we've got items, rockets, aerospace and propulsion. So that's just an indication. And there finally, look, the machine tools for materials processing, just an indication of the types of items which are controlled under the dual use goods list, if that helps at all. So now I'm going to move you on to Adrian again, who's going to be talking to us about technology and software. Over to you, Adrian.
Thank you, Claire. So the question is technology and software controlled? Well, briefly, yes. Technology and software are controlled on both the dual use and the military list. Although there are other controls, military software is controlled under ML21 of the military list, and certain dual use software is controlled under subcategory D of each of the 10 categories of the dual use lists. Controlled technology is broadly that's information for the development, production, or use of something that is controlled, as well as some of the very strategically important information regardless of what it is used for. Military technology is described under ML22 of the military list, and the dual use list is described under subcategories E. You'll also come across exceptions. One example is that information which is on public websites. This is considered to be in the public domain, a defined term which you must check, and it typically won't need a license. Further technology guidance is due to be published on gov.uk shortly. Next slide, please. Once you know you're dealing with controlled technology and software, anyone with access to the information has the means to transfer it. Each of these transfers could require a license, regardless of how the technology is transferred. Physical exports, which you can take on a flight, for example, could have you or your electronics stopped at customs. And if you haven't got the appropriate license to hand, you may not catch your flight, or worse. So although traveling with technology is a risk, of significantly higher risk to individuals and companies is electronic transfers of technology and software. We term these intangible exports. You'll see some examples of intangible transfers here, although I'm not sure who uses faxes anymore. Email is one of the easiest ways to export technology. It's a known threat. But what of the video and web conferencing tools that many of us are using today? Do you talk to your customers, suppliers, students by web conferencing application? Maybe one way you can share what's on your screen. If so, what's on your screen? What's even on the wall behind you? If it's an export control drawing of an item you want them to manufacture, test, design, and your contact is overseas, then at that very point an export may have happened and a license may have been needed. This applies to project managers, engineers, sales, marketing, lecturers, students, purchasing, procurement colleagues, and yourself. Next slide, please. As well as the consolidated control list that's available for free download from our website, there's also checker tools found on the bottom right-hand corner when you log into Spire. It's on the front page and the link to Spire is provided. These include a goods checker tool that allows exporters to review the controls in a methodical way, as well as the search facility in Spire. And there is a control list classification advice service that is to be used sparingly, but you can use it to make a control list classification request to our technical assessment unit engineers and scientists. Now, things are changing, so I'll hand you back to Claire to talk about some of the changes.
That's great. Thank you very much, Adrian. And as Adrian said, we have had quite a few changes in export control policies. And now what we're going to do is look at how we keep you informed about all the changes that take place. So this is just a screenshot of the homepage of the Export Control Joint Unit. You'll see on here actually that there's a very good customer journey to enable you to find out more about export controls and how to make licenses. It's set out so that you can actually get into Spire. Spire is the database that enables you to make the licenses. There are links in this top area here to the goods checker tool that Adrian just talked about and its sister tool for checking out open general export licenses. There's links to our training bulletin off of here. And then there's a couple of main guides to really help you determine whether you need a license, when you need a license, and what you have to do about it. So this is one of the main ways of telling exporters what you need to do to be compliant. Used with the notices to exporters, it's our key way of telling everybody when there have been updates and changes to export control policy. We don't have newsletters, and our notice to exporters service is subscription based. You'll see on our homepage that we feature the latest notices as they've been issued. I'm going to talk about that one there in a minute. Notice to Exporters 2020/11, and that was published on the 7th of July. And then I'm also going to talk a little bit about the one that was published on the 10th of July in a minute. So in order for you to get a notice to exporters, you need to be registered for the system. Sometimes the notice comes out in the form of an actual notice to exporters, and sometimes we send you the information just in an email notification, not a notice. The notices to exporters, as you can see here, will all be saved on gov.uk. If we send you email notifications with information on them, they're not saved anywhere. So it's really important that you do actually sign up for notices. I think I might have a slide somewhere that shows you how to sign up for the notices. But basically, if you go into the into one of these main guides, export controls military goods and export controls dual use items, you'll find a sign up in any of those to sign up for the notices. I said I was going to come on to this one now. Look, this is one of the notices that we've just issued. It was notifying that we have updated guidance on gov.uk. So a few words on EU transition, which I'm sure a lot of you will be interested in, and the requirement for export licences and certificates as it will be from January 2021. Just to say, the overall framework of controls for dual use exports is not going to change, but there will be changes to some licensing requirements. And we will keep you updated as more announcements are made, and we'll keep you updated via the notices to exporters. But please remember that export controls are a very small part of the requirements your businesses will need to take into account at the end of the transition period. To keep updated on all the actions, you should refer to www.gov.uk/transition, and you'll find a checker tool on that page, and that will prepare you for actions to take, whether there's a deal or a no deal. You may also want to subscribe to the BEIS Business Readiness Transition Bulletin. The email for that is sed@beis.gov.uk, as this brings together all announcements being made by different government departments. And ECJU makes our latest announcements concerning EU transition also in that bulletin. It's just another method of keeping everything together. So when we talked about, I talked about transition a little bit earlier, we talked about what will change and what won't. As we said, the overall framework of controls for dual use exports is not going to change. And to assist with the transition, what we've done is published the Open General Export Licence for exports of dual use items to EU member states. This licence also covers for exports to the Channel Islands. If you've already registered to use this licence previously, you won't need to register again. It's as with all OGLs, it's a one-off registration. Also, you don't need to use the licence until the end of the transition period, as it covers transfers that currently don't need an export licence. So for now, until the end of the transition period, if you're exporting these items to the EU, as we said before, you'll be covered by the EU Dual Use Regulation 428 of 2009. The new licence will remove the need for you to apply for individual licences, and it can be used immediately after the UK leaves the EU. As we talked about before, registration is on SPIRE, and that's the online export licensing system. Conversely, your suppliers moving items from the EU to the UK will also need a new licence issued by an EU member state for exporting dual-use items from EU member states to the UK. The European Council has put measures in place to add the UK as a permitted destination to Union General Export Authorisation, GEA, EU 001. This is again to minimise any additional licensing burden for those exporting dual-use items from the EU to the UK. Again, please also ensure you're signed up to our email service. Also, how you get our notices to exporters to keep up to date with any changes to these arrangements and how they may affect your exports. I promised to come to another of the announcements that we've just made. Using a notice to exporters. This notice to exporters 2020/11 were provided exporters with background on the Secretary of State for Department for International Trade's decision about the licensing handling arrangements for Saudi Arabia and the coalition partners. Following the written statement by the Secretary of State for International Trade informing Parliament that she's retaken her decisions regarding licences for military exports to Saudi Arabia for possible use in the conflict in Yemen in accordance with the judgment of appeal of the 20th of June 2019, several actions have now happened. The undertaking given to the court that we would not grant any new licences for the export of arms or military equipment to Saudi Arabia for possible use in Yemen falls away. The broader commitment that was given to Parliament relating to licences for Saudi Arabia and its coalition partners also no longer applies. In ECJU, we've now begun the process of clearing the backlog of licence applications for Saudi Arabia and its coalition partners, which has been building up since the 20th of June last year. Each of these applications will be carefully assessed against the consolidated EU and national arms export licensing criteria, and a licence would not be granted if to do so it would be a breach of that criteria. You should be aware that it may take some months to clear this backlog. There's quite a few of them. There may also continue to be delays in processing new applications until the backlog has been cleared. But I can assure you the licensing unit and everybody involved is working as fast and as efficiently as we can to get these licenses cleared. So we've talked quite a bit already about controls and the sanctions and the control lists and all of that. You'll notice that we actually haven't touched on anything to do with licensing yet. And I'm going to hand you over to Adrian now, because he's going to test out your knowledge to see exactly what you do know in terms of licensing. So I'll pass you, I'm going to pass back to you now, Adrian.
Right, thank you, Claire. So let's start with the licenses, as mentioned. If you're not familiar with the range of export licenses, these are in bold and are used for straightforward exports from the UK to overseas destinations. They come in many different flavours, and some you may have seen before. The difference between a standard licence and an open licence is that standard licences are only valid for a set period of time, and they're restricted to one end user. We receive about 17,000 of these applications every year. The validity is up to 2 years. They can be revoked if trading climate changes, i.e. sanctions are imposed in the country. Oil's open individual export licenses are similar, but they can be valid up to 5 years and can include a number of named end users in different countries. But before applying for a SEAL, a standard individual export license, you should check first whether you can use an open general export license. These are pre-published licenses permitting export of a specified range of controlled items to a specified range of destinations. Terms and conditions apply to all of these, and they are often different. So you should download the license and read it through to check that it applies to your goods and your activity before registering, and definitely before using it. The Open General Export License Checker tool will also help you with this decision, and it sits alongside the Goods Checker tool we saw earlier on. However, if you're moving military goods from one third country to another, i.e. both destination and source country are outside the UK, trade control versions of these licenses can be applied for. Unfortunately, quite a lot of these license applications have a lot of mistakes. So I'll hand back to Claire to go through some of the most often mistakes. Claire.
Thanks, Adrian. I've just popped this slide up here. We've done this in collaboration with the licensing unit to get an indication of where we can help you in terms of the mistakes that sometimes occur on SEAL applications. Let's look at the first one there about end user undertakings. It's a requirement of a standard individual export license application to attach one of these end user undertakings from the ultimate end user. And this is one of the main reasons that can hold up a license if these are not completed properly. I should also say here, I've just talked about ultimate end users, and there are also other types of consignee declarations as well. You'll need to have a look at all the different types of these. But one change we've made in lockdown has been the acceptance of digital signatures in certain circumstances. And that has made it substantially easier potentially for some companies, because getting a wet signature had proved difficult. And one thing I will say here is that the replacement digital licensing system for Spire, which is shortly going to happen, that's known as Light, that will enable acceptance in all cases when it's finally launched. Let's look at the next one down. Adrian's been talking about technical specifications, and it's important to attach all technical information relating to the goods lines so that our technical officers can classify the items that are on your application. It's also important to make sure that you supply all the related paperwork for the order, because we need to check that the export license application covers all the controlled items in the shipment that you're going to be sending, and that will be evidenced from the purchase order and any invoices. So what I would say on this is please double check all your applications before submitting them. And one of those is if there are lots of goods lines, sometimes if you have loads and loads of goods lines and you're putting complicated information in there, detailed information, sometimes that can cause errors, and indeed sometimes you miss out the goods lines. So make sure that all of the goods lines are included. So all of the points I've just made are reasons why the licensing officer that's been allocated to you would need to request further information. When that comes to you, it's known as an RFI. And I'm sure you'll agree this delays your licensing processing and extends the time taken before you receive a decision on your license. If the Spire officer in your organisation is away on holiday, for instance, ensure the access is available to someone else to check when we require additional information. Sometimes this can all get held up if only one person in your organisation has actually got access to Spire. Adrian also talked about open general export licenses, and for those of you that use these, you will know that you get visits from our compliance inspectors. And again on these, there are several errors in the way the licenses are used. So I think it's a good idea just to run through some of those to bring those to your attention. The thing is, the compliance inspector from ECJ is going to conduct these audits on the use of your open licenses. So that could be your OGLs, the open individual export licenses, the open general trade control licenses, and any of the standard individual licenses which won't be presented to customs, for instance, for electronic transfers. So it's quite a lot of licenses that they'll be looking at. There are often a number of errors in the use of these licenses, which can lead to a requirement to make voluntary declarations to customs. They also can lead to warning letters from the compliance inspectors to ensure that you improve your compliance practices, and in some cases you will have your open general export license revoked, and that's a nuisance, because what that then means is that you actually have to apply for seals. So it's imperative that when you're using these open general export licenses, you ensure the destination for which you're using them for to send a particular shipment is permitted on the relevant OGL. And sometimes these are listed either as permitted destinations, or the countries are listed as the non-permitted destinations. So do be careful when you're looking at the OGL, look at it carefully to make sure that the country that you want to send your items to are actually enabled. You can send it to those countries. You should also make sure that the OGL that you want to use actually contains evidence of the control list item that you want to export. If you want to export widget A and widget A is not on that particular OGEL, then you won't be able to use it. You'll have to apply for a standard individual export license. So please always check that the control list item is actually on the OGEL that you're wanting to use. Because as Adrian said, the OGELs are all very different. They all contain different things, they all contain different control list items and different countries and destinations. So you must make sure that the relevant license you want to use contains all of these things on control lists that match your shipment. And it's also important that you meet all the individual terms and conditions of the separate licenses. As Adrian said, they're all different. I did ask her about open individual export licenses, and apparently the mistakes on open individual licenses is sometimes those open licenses, which are valid for up to 5 years, are used after the expiry date. So again, check the expiry date on open individual export licenses. Okay, so hopefully that will be some help when you're using your open licenses. I'm going to pass you over to Adrian again now to cover what happens if these things aren't done. Adrian.
Thank you, Claire. So, although Export Control Joint Unit are the licensing authority, we don't carry out breaches or investigations. We leave that to Her Majesty's Revenue and Customs, who carries out the investigations of any potential breaches of these controls. Fortunately, there are very few serious cases for HMRC to deal with most minor cases dealt with by warnings or fines. It's just like the approach used by the police in response to driving offences. But some offences can lead to full prosecutions and can result in unlimited fines up to 10 years in prison if it's serious enough. And HMRC have been known to make public announcements about prosecutions as warnings to others. Claire.
Yes, I'm coming.
Claire will now keep you how to keep updated.
So what I'll say on this, just keep updated. We've covered a fair amount today, I think, between us, Adrian. And I think what I'd like to look at is how you, as the exporter, can keep yourself informed about the requirements that we've both talked about, and how you, as the exporter, can stay updated about changes at the same time. The first thing I want to have a look at, I want to return back to that home page. There are some very useful guides on gov.uk to fully explain the requirements for licenses and the steps that you do need to take. I talked about the customer journey before, and this is a good way of helping you to take the right decision about whether you need a license and which license to use and how to apply. These, as I said before, these are the two main guides: Export Controls Military Goods Software and Technology and Export Controls Dual Use Items Software and Technology. These guides actually lead off into quite a few other very, very detailed guides that will help you to understand about all the different licenses, the different legislation, the different controls. So please do use this as a first point of contact. And what I'll also point out here is, if you look right at the top here, there's a link that will take you directly through to the SPIRE licensing database. And that's where you will make all your applications for licenses and also register for your open licenses on the SPIRE database. I'm now going to pass you back to Adrian.
Thank you, Claire. I've been passed back because this is something I produce. We try and produce this every 3 to 4 months to show when the next training courses are going around the UK. So we run training courses in London and all the UK regions. Our latest bulletin on gov.uk includes dates for classroom-based courses from September to December 2020. However, things can change, as we know, so we've also been delivering some bite-sized extracts of these courses in a webinar format, which have proved to be very popular. If you want to have a copy of any of those previous webinars, then please contact Denise Carter, whose email will be at the end of this presentation, and you'll be able to obtain copies from there. And please sign up to the email service as mentioned before by Claire, because then we'll tell you when the next webinar is going to be provided. When I first started this export control journey 20 years ago, it was many parts of a sideline. Since then, it's become much more professional. So I believe you want to now speak about the profession, Claire.
I do, Adrian. But before I speak about the profession, I do just want to say that, tell everybody that about the training you delivered yesterday. It was an online training. It was an introduction to export controls, and we had 1,300 delegates registered. So that was excellent outturn for that. And I actually hope that a good proportion of the exporters that are dialing into this webinar today will have listened to you as well. So I just wanted to say that. Now, I'm going to move us on to the export control profession. And Brynley, would you like to say a few words, please, about the profession? Welcome.
Thank you very much, Claire. Control profession was established under the Institute for Export fairly recently, is trying to provide a degree of professionalization to the whole export control arena, and therefore being able to try to enable its members to build up a portfolio of experience and knowledge, which can then help them in their career progression with their employers. And therefore it was established. The chairman is an ex-Rolls-Royce official, Roger Arthey, and he's got a board which helps him to steer its activities, and it gets involved in a whole host of activities, including training and other efforts to try to professionalize the export control arena. It's known that it's realized that at the end of the day, whilst in the olden days, it might have been a perception that export controls was simply a simple menial administrative clerical task which could be handed to anyone. And I've known of cases where it's been simply given to someone in the shipping department, for instance, to do. Actually, export controls is a vital expert function, requiring its practitioners to try to be able to interpret complex legislation. And it's not just national legislation. In many instances, you have to have a good working awareness of international similar jurisdiction regulations to understand what you can and cannot do, and be able to identify how the export controls will impact on what it is that you've got and what it is you want to do. So you need to be able to interpret these various international regulations and also match them against the technology which is in question. And therefore, it's vitally important for the export control profession to be recognized as being this vital expert function, and we're hoping that the export control profession will be one effort to try to establish that credibility for the profession. Thank you.
Lovely, thank you very much, Brynley. That was really helpful, and we're all very excited about the profession, and obviously. And the more people that sign up to it, the better it's going to get. So it's a question of watch this space and get involved. Thank you very much. Oh, Well, it looks as though we've probably come to the end of what we wanted to say for today. I'd just like to say thank you very much for listening in. And if there is any questions from anybody, it would be good to take them now.
Claire, I have some questions. Thank you to you and Adrian for fantastic and clear presentations, which have been invaluable. But some nations have a form of dual licensing systems whereby exporters have the ability to apply for a marketing license before they enter into any marketing promotional efforts to pursue a potential opportunity. And then if that's successful and it's granted and their efforts work and they win the contract, they actually apply for the export license to actually ship the goods to the overseas customer. What mechanisms exist in the UK and our regulations for UK companies to test the water to see whether an export license might be issued or not?
I think fundamentally the answer to that is there is no such marketing license that is issued by the Export Control Joint Unit. All of our licenses are for either export for sale or exhibition, for instance, or for trade licenses. So we don't have that form of marketing license. And the reason for that is to give a marketing license, then that gives as an indication of whether a license will be accepted. It is quite difficult. When it comes to giving licenses and giving permission for licensing, all actual applications for export licenses themselves are all assessed on a case-by-case basis. And that's all dependent on the trading situation, the risk situation at the time of when that export is going to happen. And a marketing license could have been granted several months or even years in advance, and things change so quickly, which is why we just have the one export licensing system.
Can I also add to that is that remember that export licenses don't always need a purchase order or an invoice, and we do see certain exporters who will apply having obtained the right documentation, the end user undertaking and the full scenario from a potential customer before a contract is let. And if the contract is never let, then they're one of the licenses which, although issued, is never used.
And I was also, thanks for that, Adrian, I was also going to say that we talked earlier about the MOD Form 680, and that's about the only one that's got that requirement to require a license for marketing. And that's the MOD Form 680, as we said before, is for exports of items which are classified official, sensitive and above. That's required for marketing purposes. So, but that's a different type of licensing. I hope that helps, Brynley.
Yes, thank you very much. Another question. Can an overseas company with absolutely no presence at all in the UK make use of the UK's licensing system where this might be relevant? For instance, if you've got controlled goods in the UK, which they need to be moved from the UK back to where they came from, or do they always have to have a UK party to apply for their license on their behalf?
They don't always need to have a UK. If they've got a UK address, then they can use the SPIRE system. Many companies, when they're doing this and arranging for freight to be shipped from outside their country, so freight to be shipped from the UK elsewhere, would use the services of a freight forwarder who would have a UK address. So it's very dependent on the makeup of the company, the overseas company, as to what addresses they've got. But fundamentally, you can register on SPIRE if you've got a UK address. I'm going to pass that back to Adrian because I think that's the correct answer.
I have the legislation here. So the Export Control Order of 2008, which sits underneath the Export Control Act, Article 27 covers persons authorised by UK licence to export controls. And it says who can actually get hold of a license and who the license holder will be. And one of the terms and conditions here is that the license holder is established within the customs territory. So in this case, for military goods, that's the UK. For European Union dual use goods during the transition periods, that's the EU. But every scenario is different and every situation may challenge the normal boundaries. And so the regulations should be checked. That's Article 27 of the order.
Thank you much. Following on from that, with regard to trade controls, and Claire mentioned the trade controls, can a non-UK company apply for a trade control license to cover its UK expatriate workers if they fall under the licensing requirements on their behalf, or does it require the individuals to apply for the trade control license when they're caught, and it can't be done at the corporate level?
Passing to Adrian.
that is, I understand that. So what is being discussed here is that UK nationals overseas can be bound
Yes.
by UK regulation if they are involved in the movement of certain military goods to certain destinations from one non-UK place to another non-UK place. How that would be registered for a non-UK national, I think that would have to be a discussion held with our license reception of how would be the best way to manage that, because without a UK footprint, there isn't a UK EORI number that they could possibly use to register onto Spire. And so the license reception would have to look at those particular fairly unique and rare cases, but they do exist because we do have UK expats, UK dual nationals around the world being involved in some of these dealings. So that will probably have to be handled on a case-by-case basis.
Okay, thank you. Another one is about electronic signatures. Certainly when the compliance inspectors are undertaking their audits, quite often for key documents such as end-user undertakings, they insist on sort of wet signatures and original documents. But of course, in the current climate with the COVID-19, they've been flexible in adopting new arrangements, and now electronic signatures are temporarily permissible and accepted. What is the potential impact? Has this been a success? In which case, you might be prepared to extend this temporary system, or and make it more permanent, or what with regard to electronic signatures?
That's an interesting question, Brinley, and it's something that we had looked at for a while, and obviously with COVID, it's a solution. It's the solution currently, because wet signatures are obviously very difficult to get. It's proving interesting, but as you said, it's only currently being accepted in certain circumstances, and I think you made reference there to the fact that I think for compliance purposes there is still a need for a wet signature. One good thing on the horizon is that when we eventually get our new licensing system to replace Spire, so Light, there will be a facility on Light to enable electronic signatures to be accepted.
Thank you. Another one is we often get queries from our member companies about cloud computing and trying to understand the whole subject of cloud computing, what the regulations are and what they need to do to try to comply with it. The existing guidance was published in 2010. Whilst it was perfectly up to speed and valid back then, are there any, I think you referred to it, have you got any idea about the timescales for the introduction of publication of new guidance on the technology sector?
Right. Okay. Well, yes, we have, is the answer to that. But first, before we look at that, I'd really like to point you to the excellent technology and information webinar that Adrian presented in May. We've got a ready-made webinar on information technology, and cloud computing. So I really would advise everybody to get access to that. We've got the recording link. We sent it out to everybody that was part of the webinar. If anybody wants access to that, then please do let us know. We're trying to get it available on the DIT YouTube site at the moment. So it's a question of watch this space on that. But I'd certainly say to people, have a look at that particular webinar. There is another piece of guidance, which is a detailed guide, which can be downloaded from gov.uk. We're very, very close to finishing the complete upgrade of that guide, and are very hopeful that it will be in a position to be published certainly within the next couple of weeks.
Yeah, I've seen a draft of that coming very close to completion now.
Yeah, so I think that's nearly ready to go.
And I believe he does mention the word cloud.
Always helpful. Thank you. Another thing, can the ECJU provide any assistance or guidance to UK exporters when they have any queries about other nations' export control systems? Is it simply purely you can only provide guidance on your own, on the UK national regulations?
Really, yes, we can only provide guidance on our own regulations. I mean,
I don't know. Do you know anything about the Australian export control system, Claire?
we don't.
No. Hong Kong, New Zealand.
Where this all comes, you know, UN Security Council regulation, what is it, 1540, puts the obligation on all governments to get these licensing systems put into place. And then every country has their own licensing system. So we have our pieces of legislation and we have our processes, but they're all going to be different to other countries. They're all working towards the same thing, which is to prevent the proliferation of weapons of mass destruction and military end use and all of that. But we do it in a different way. Licenses may look a bit familiar, but they're not the same at all. So I think the answer to that question is no, we can't.
But I take it that potentially any UK companies who have those sorts of queries could make contact with the British embassies or high commissions in those countries to see if they could provide them with any advice. Absolutely,
that's a really good route in, because you know, there are high commissions and embassies in the UK. That's a good route in to finding out who the licensing authority is in each of these overseas states. Definitely.
And of course, we have British nationals representing UK business in a lot of those overseas nations, and they'll have access to that information locally as well.
And I'd like to also reiterate and reinforce your messages, Claire, and also Adrian, about the need for companies to read the OGELs very carefully, the terms and conditions of the OGELs very carefully. There's a particular case study which I know about of one of our member companies who, some years ago, they wanted to do something. They looked at a relevant OGEL, tried to look at the schedule at the back to see if the country's name was on the list of countries, and it was. Oh, that's fine. We can do that then. And then just before they were actually about to ship the item to the country, a bright spark from the company decided to get out the OGEL again and just look at it one more time, and noticed to his horror that at the top of the page it said this OGEL is relevant for every country in the world other than those on the following list. Thanks to the ECJU's valiant efforts, the company did manage to get a seal in time to cover what it wanted to do, but it was a close run thing, and therefore I cannot reinforce the message strongly enough. You need to read the terms and conditions of the OGELs very, very, very carefully, just to make sure that it does cover what you want to do.
Yeah, I would second that. We run on the classroom-based courses an exercise where we do have people reading real licenses and giving them real situations to look at, and they learn, usually in pairs or in threes, to work together to read through these things. I say from cover, the main title, to the crown cap right at the end, twice, just to see if they understand how that license works, because all of them are different.
Mm.
And again, this reiterates the fundamental message of the need for the export control profession. It is export controls is a vital expert function, and you need to be able to read and interpret the regulations and the wording of licenses, just to make sure you can interpret how it impacts on what you try to do.
Yes, the more that this becomes a profession, the more specialist people become, the more they can do for their businesses to ensure they do better business.
Exactly. That's all my questions.
That's all your questions.
Yes.
Well, really, I thought they were some quite searching questions there, and I hope
yes,
you're able to answer them, and that others will take something from that. So I suppose it just leaves to be said, that's all we have to say here. We hope everybody that comes to FIA Connect and actually listens to this webinar finds it of use and information and as informative. If there are any questions people have, then I think we've got a contact on the slide somewhere.
that might be the next slide.
That might be the next slide. So we let's just see where that is. Might be the next slide, but unfortunately, there it is. Yes, there is the slide. So we've got a helpline. If you really want to talk to somebody about how to fill in your application, or just some basic background information, then by all means talk to our ECJU helpline. We've got an email address there, and we've also got a telephone number. Really helpful team of people on the helpline. Adrian and I are always on hand to give you any help that you want. I know Adrian, after has done his training courses, regularly goes on to help companies who have attended those trainings to help them understand it in more detail. I'm happy there to take any inquiries as well and to talk to others across ECJU. And please don't forget that Denise is our font of all knowledge in terms of bookings and training courses and dates and all of those things. So do please get in touch with Denise if ever you need any further help.
Okay.
Okay.
Thank you very much, Claire and Adrian.
Thank you very much, Brindley. Thank you, Claire.
Thank you.
Thank you very much.